a very important judgment coming from the Supreme Court of India in the case of Messrs. Safari Retreats Private Limited. We will be diving deep into this much anticipated Supreme Court judgment as it is a very important judgment. This landmark judgment was delivered on October 3, 2024. It addresses crucial aspects of the GST regime, particularly the very important one, input tax credit, and the interpretation of many provisions of the CGST Act. First of all, this particular case originated from a dispute over the construction of a shopping mall and the availability of ITC on the GST paid on the goods and services which were used in the construction of that mall. This case has a far-reaching implications for the real estate and the construction sectors, as well as for understanding the ITC under the GST framework. In this video, we will examine the case background, the legal issues at stake, and the Supreme Court's reasoning, and the potential impact of this judgment on the businesses as well as the tax practitioners. First, let's understand what was the facts of this case, what was the background of this case. The saga began with the company Messrs. Safari Retreats Private Limited. This company was engaged in the construction of shopping malls with the intention of letting out the premises of the mall to the various tenants. During the construction process, the company accumulated a substantial amount of ITC. It was a huge amount of rupees 34 crores. This ITC was accumulated on the purchase of goods and services essential for the mall's construction, like cement, sand, steel, wires, plywood, paint, and some services like installation of lifts, escalators, air conditioning plants, and various professional services. The crux of the issue arose when the Safari Retreats sought to utilize the accumulated ITC against the GST payable on the rental income. The crux was when the company sought to utilize the ITC against the GST payable on the rental income which they would receive from by letting out the premises of the mall. However, they were advised by the tax authorities to deposit the GST on rental income without deducting the ITC. This advice was based on the exception which is given in section 17(5)(d), that is block credits. Agreed by this situation, the company filed a writ petition before the High Court of Orissa. The petition sought many reliefs. The first one was that of a declaration that section 17(5)(d) of the CGST Act does not apply to the construction of immovable property, which is intended for letting out on rent. Alternatively, if section 17(5)(d) was held to be applicable, a declaration that it violates Article 14 and 19(1)(g) of the Constitution of India. Also, the company requested the court for a writ of mandamus, directing the tax authorities to grant the benefit of ITC to the company. The High Court of Orissa, in this judgment, which was dated on April 17, 2019, ruled in the favor of the company. The High Court's decision was based on a reading down of section 17(5)(d), which drew inspiration from a Supreme Court judgment, which was an earlier decision in the case of Eicher Motors. The High Court held that if an SSC is required to pay GST on rental income for a mall, they should be entitled to avail ITC on the GST paid for the mall's construction. This decision by the High Court of Orissa was not well received by the tax authorities. Consequently, the Chief Commissioner of Goods and Service Tax and others filed an appeal before the Supreme Court of India, which challenged this High Court's interpretation and also for seeking clarity on the application of section 17(5)(d) of the CGST Act. Also, to note that this case did not stand alone. There were other several writ petitions which were filed challenging the constitutional validity of Clause C and Clause D of section 17(5). The petitioners contended that due to restriction imposed by these provisions, they were unable to get the credit on the GST paid on the goods or services used in the construction factory premises, building, and other structures against the GST received for renting, leasing, or letting out these premises. Given the significance of these issues, and their potential impact, particularly on the construction sector and also the leasing part, the Supreme Court decided to hear these matters together. Now, as we have studied the background of this case, it is very important to fully grasp the sections as to study the implications of this case. The first section is section 16, which talks about the eligibility to claim ITC. It states that every registered person shall, subject to such condition and restrictions, be entitled to take credit of the ITC charged on any supply of goods which are used or intended to be used in course and furtherance of the business, and it will show in the electronic credit ledger. This provision basically establishes the principle that ITC can be claimed on the inputs used in the course or furtherance of business. The right is subject to certain conditions, which brings us to the contentious section of 17. The section 17 talks about block credit. This particular section deals with situations where the full amount of ITC cannot be claimed. If we talk about our particular interest, subsection 5C and D are in question. Subsection 5 states that, notwithstanding anything contained in subsection 1 of section 16 or subsection 1 of section 18, the credit shall not be available in the following, namely two parts, C and D. C talks about works contract services. It states that works contract services, when supplied for construction of an immovable property other than plant and machinery, exceptions other than plant and machinery, except where it is an input service for further supply of the works contract service. And D states that goods or services or both received by the taxable person for construction of an immovable property other than plant or machinery, right, plant or machinery, on his own account, including when such goods or services or both are used in the course or furtherance of business. These provisions effectively block the availability of ITC for goods and services used in the construction of the property, the immovable property, with certain exceptions, that is the plant and machinery and plant on machinery. The interpretation of these exceptions, particularly with the meaning of plant and machinery in clause C and plant or machinery in clause D, formed a crucial part for the Supreme Court's reasoning of this judgment. If I tell you about the explanation which is appended with the section 17, which talks about the definition of plant and machinery. I'm not talking about plant or machinery. I'm talking about the plant and machinery definition. It states that for the purposes of this chapter, plant and machinery means apparatus, equipment and machinery which is fixed to the earth by foundation or structural support, and they are used for making the outward supplies for goods or services or both. It includes the foundation and structural supports but excludes three things. First, land, building and other civil structures. Second, telecommunication towers. And third, pipelines which are laid outside the factory premises, right? So this is the explanation which is appended to section 17. This definition becomes particularly important when we consider the difference between plant and machinery, which is given in clause C, and plant or machinery in clause D of section 17.5. Now we will also understand the schedule 2 of the CGST Act. Schedule 2 of the CGST Act is also relevant as to our discussion, because as it specifies the activities to be treated as supply of goods or supply of services. Particularly if we talk about clause 2 and clause 5. Clause 2 talks about land and building. It states that any lease, tenancy, easement, license to occupy land is a supply of service. B states about any lease or letting out of a building, including commercial, industrial or residential complex for business or commerce, either wholly or partly, is a supply of services. Clause 5 talks about the supply of services. It states that the following shall be treated as supply of services. The first one is renting of the property. Second one is construction of complex building or civil structures or part thereof, including a complex or building intended for sale to a buyer wholly or partly, except when the entire consideration has been received after the issuance of completion certificate where required by the competent authority, or after its first occupant has come, whichever is earlier, the completion certificate or the first occupant, whichever is earlier. These provisions are very crucial in understanding how the renting of the immovable property works and the construction of building, that how they are treated in the under the GST regime. Right. Now we will talk about the Supreme Court's analysis and decision. The Supreme Court, the Supreme Court's judgment, running into 91 pages. Yes, it was of 91 pages. It provides a comprehensive analysis of the issues at hand. Now we will be breaking down the court's reasoning on each major point. The first one was constitutional validity of section 17(5)(c) and D. The court upheld the constitutional validity of clause C and D of section 17(5). In reaching this conclusion, the court relied on several established principles of the constitutional law as well as the taxation law. The first one was the legislative competence and economic policy. The court here emphasized that in matters of economic policy and taxation, the lawmaker enjoys wide latitude. The court cited the case of R.K. Garg, in which the court reiterated that the lawmaker has greater freedom in the matters of classification for taxation purposes. This principle acknowledges basically the complex nature of economic decisions and the need for flexibility in fiscal policy making. Now, if we talk about reasonable classification, the second principle was reasonable classification. The court found that the classification made by section 17(5)(c) and 17(5)(d), it satisfies the test of reasonable classification under Article 14 of the Constitution. It referred to the case of Typhoid Tea Company. The court held that differentiation between immovable property and other goods for GST purposes constitutes an intelligible differentia with a rational nexus to the object of legislation. The third principle states that less rigorous test for tax laws. The court here applied a less rigorous test of discrimination of tax laws as established in the case of Union of India versus Nitdep Textile Processor Private Limited. And this approach recognizes the complex nature of fiscal adjustments and allows for greater flexibility in the tax legislation. The second reasoning was about the nature of input tax credit. It was one of the most significant aspects of the judgment. Right. The court here unequivocally held that ITC is a statutory right and not a fundamental right or a constitutional right. This classification is crucial because it allows the lawmaker greater latitude in defining the scope and limitation of the ITC, the input tax credit. The court here relied on the case of ALD Automotive. The court affirmed that the right to claim input tax credit is a statutory right, and the statute itself has provided for the manner in which such rights is to be exercised. There's no constitutional entitlement to seek a refund. Parliament has, in clause I of the first proviso, allowed a refund of the unutilized ITC in case of zero rate supply, and also clause 2, which talks about the inverted duty structure, right, where the credit has been accumulated on account of the rate of tax of inputs being higher than the rate of tax on the output supplies. This characterization of ITC as a statutory right has got some significant implications. It means that the lawmaker has the power to impose restrictions or conditions on the availability of ITC as stated in section 16, as long as these restrictions do not violate other constitutional principles. Now, the third reasoning was about the interpretation of plant or machinery, which is given in section 17(5)(d). It is perhaps the most nuanced and potentially far-reaching aspect of the judgment in the court's interpretation of phrase plant or machinery, which is used in section 17(5)(d). Right. The court held that this phrase cannot be given the same meaning as plant and machinery, which is defined in clause C of section 17(5). This interpretation opens up new possibilities of claiming ITC on the construction of certain type of immovable property. The court's reasoning on this point was basically as The court basically told about the lawmaker's intent. The court noted that the lawmaker intentionally used different expressions, plant and machinery, in several places, and plant or machinery only in section 17(5)(d). This deliberate choice of words was seen as indicative of distinct legislative intent. And also the court talked about the rejection of drafting error argument, which was put by the lawyers. The court rejected the argument that the use of or instead of and in the section 17(5)(d) was a drafting error. It is noted that if it were a mistake, the lawmaker could have corrected it in 5 years since the High Court judgment on this issue, right? As it was in 2019. Also, the court also held that plant or machinery has a different connotation from plant and machinery. It can be either a plant or machinery, whereas plant and machinery requires both elements to be present, right? Also, the court observed that if the said contention is accepted, there will not be any difference between the expression plant and machinery and plant or machinery, which will defeat the lawmaker's intent. The fourth the fourth major reasoning was the functionality test. Building on its interpretation of the plant, basically it was about determining about what is a plant. This particular test was given for determining what is the meaning of plant, right? So building on its interpretation of plant or machinery, the court introduced a functionality test to determine whether a building qualifies as a plant under section 17(5)(d). So the court gave some test. The first one was the business should be of a registered person. Second, the role that the building plays in that business. The third one was whether the construction was essential for carrying out the activity of supplying services. The court stated that if the construction of the building was essential for carrying out the activity of supplying services, such as renting or leasing or other transaction in respect of that building or part thereof, which are covered by the clause 2 and clause 5 of schedule 2 of the CGST Act, the building could be held as a plant. This approach for a case by case determination, recognizing that different buildings may serve different purposes in various businesses, the court draw inspiration from the cases like CIT Trivandrum versus Anand Theatres and Commissioner of Income Tax versus Victory Aqua Farm Limited, where special structures were considered plants based on their functions in their business. Right. The fifth reasoning was given about the applicability of this provision to shopping malls and similar structures. The court held that whether a mall, warehouse, or any building other than a hotel or cinema theater can be classified as a plant within the meaning of plant or machinery in section 17(5)(d) is a factual question. This determination must be made based on the functionality test which the court have outlined. Importantly, the court specifically excluded hotels or cinema theaters from this consideration based on the previous jurisprudence that had classified these buildings rather than plants. The court stated that therefore, by using the functionality test in each case on the facts in the light of what we have held earlier, it will have to be decided whether the construction of property is a plant for the purpose of section 17(5)(d). And now if we talk about the implications for the input tax credit, the court's interpretation has significant implication for the availability of ITC. It clarifies that if a building qualifies as a plant under the functionality test, ITC can be availed against the supply of services such as renting, leasing, raising the business or premises. This is subject to meeting the terms and conditions of the CGST rules, CGST Act and CGST sections and rules. The court explained that under the CGST Act, renting or leasing the property is deemed to be a supply of service and can be taxed as output supply. Therefore, if the building in which the premises are situated qualifies as a plant, then ITC can be allowed on goods and services used in setting up that immovable property. The interpretation potentially broadens the scope for businesses to claim the ITC on the construction of certain immovable property, particularly those that are integral to their service offerings. Right. The court also discussed some principles about the interpretation of taxing statutes. referring to various cases. It emphasized that while tax statutes should be interpreted strictly, if two interpretations are possible of a particular provision, the one favoring the assessee should be adopted, not the department. However, the court also noted that the principle should not be stretched to a point of creating additional fiscal burdens on the persons or reading words into the statute. The court the court here rejected the approach of reading down section 17(5)(d) that was adopted by the High Court of Odisha, while acknowledging the principle from cases like uh, Indian Social Action Forum versus Union of India, that reading down can be used to preserve the constitutionality. The court found no that, that the court found no ambiguity or unconstitutionality of that provision that would necessitate this particular approach. Also, the court addressed the argument that section 17(5)(c) and D were vague due to the undefined terms. Referring to the case of Shreya Singhal, the court acknowledged that excessively vague provisions can be struck down. However, the court found that the provisions in the question were not vague to the point of unconstitutionality. Right. The court also discussed the nature of transactions under GST, referencing to the case of Bharatiya Sanchar Nigam. It emphasized that the GST regime focuses on supply of goods and services, and the classification of transactions should be based on its dominant nature. Right. Now we will be studying about the implications of the judgment. This landmark judgment has significant implication for the real estate and construction sector under the GST regime. Right. Now we will be exploring these implications. The first implication is that of broadened scope of ITC claims. By providing a nuanced interpretation of plant or machinery and reducing the functionality test, the court has potentially expanded the scope for the businesses to claim ITC on construction of certain immovable properties. This is particularly relevant for properties that are integral to service offerings, such as shopping malls, warehouses, and similar structures used for commercial letting out. The second implication is that it talks about case by case determination. The functionality test introduced by the court states a case by case examination of whether a particular building qualifies as a plant or not. This approach allows for a greater flexibility but also introduces an element of uncertainty, as the classification will depend on the specific facts of each case. Now, what is the impact on real estate and construction sectors? The judgment provides a pathway for the businesses in the real estates and the construction sector to potentially claim ITC on construction cost, provided they can demonstrate that the building meets the criteria of a plant as per section 17(5)(d) under the functionality test given by the Supreme Court in this judgment. This could lead to significant tax savings. Right. The fourth one was this in the judgment has put challenges for the tax authorities. The case by case approach mandated by the court may pose challenges for the tax authorities in terms of consistent application and enforcement. It may lead to increased scrutiny and potential disputes over the classification of buildings as plant. And the fifth implication will be basically planning opportunities for business. The judgment opens up new planning opportunities for businesses. Companies may now consider structuring their operation and property usage in a ways that maximizes the potential for claiming the input tax credit under the new interpretation given by the Supreme Court. Right. And also, given the court's interpretation and its potential fiscal implications, there may be legislative responses to clarify or modify the relevant provision of the GST Act. The lawmaker may clarify the meaning of plant or machinery in further stages. Right. And if we talk about the implication for specific sectors, while the judgment potentially benefits the businesses constructing properties for commercial letting out, it may have limited applicability to other sectors. For the instance, the court specifically excluded the hotels and cinema theaters to be considered as a plants based on the previous jurisprudence. Right. And Also, the court's reaffirmation that the ITC is a statutory right and not a fundamental right or a constitutional right underscores the lawmaker's power to impose conditions and restrictions on the input tax availability. This may have implications for future challenges to the ITC related provisions. Right. Also, one more point, the court's differential approach to legislative wisdom in complex economic matters is that the future changes in the GST provisions on constitutional grounds may face significant hurdles unless they can demonstrate clear violations of the fundamental rights or basic constitutional principles. Right. And if we talk about the functional analysis of this judgment, the judgment emphasizes that the need for a detailed functional analysis of how immovable property is used in a case of business. Right. This may require businesses to maintain more comprehensive documentation for their property usage and its relation to their service offerings. Right. Now, a very important part. If we talk about the potential challenges and questions which will be arising from this judgment, the first one, defining the parameters of functionality test. The Supreme Court has introduced the functionality test but has not provided detailed guidelines on its applications. This may lead to uncertainty and potential disputes between the taxpayer and tax authorities. And second one, it is a very important one. The judgment does not directly address how to treat properties that have mixed usage, right? Partly for letting out and partly for other purposes. This may require further clarification or litigation. The third one, the retrospective application. The judgment does not explicitly addresses where its interpretation can be applied, whether the interpretation of this judgment can be applied retrospectively. This may lead to the questions that about the past ITC claims and potential refund applications. The fourth one, impact on ongoing projects. What about the ongoing projects? For the construction projects that are currently underway, there may be questions about how to apply the new interpretation, especially if the ITC has already been denied based on the previous understanding of the law, right? And what about the burden of proof? The onus of proving that a building qualifies as a plant under the functionality test will likely fall on the hand of taxpayer or the GST department. This may require businesses to maintain additional documentations and also evidence to support their ITC claims. The sixth point, potential for deferring the High Court interpretation, as the Supreme Court has remanded the case to the High Court and directed other cases to be decided on their merits. There is a potential for differing interpretation by various high courts, which may eventually require further Supreme Court intervention and litigation. Right. And also, if we talk about the like while the case primarily dealt with the shopping malls, the principal lead down may have implication for other sectors also, such as healthcare, hospitals, education, school, colleges, and hospitality, excluding the hotels. Right. However, these principles will apply to these sectors remain to be seen. Also, a very important one, it talks about the valuation issues. If a building is classified as a plant, question may arise about its valuation for GST purposes, particularly in cases of partial letting out or the mixed usages. It is a very important one. Now, moving towards the conclusion of this judgment, the Supreme Court's judgment in this particular case represents a significant development in the interpretation of GST law, particularly concerning the treatment of input tax credit for the construction of immovable property. By upholding the constitutional validity of the challenged provisions while providing a nuanced interpretation for the plant or machinery and the term plant and machinery, the court has struck a balance between the legislative intent and business realities. And also, the court has introduced functionality test for determining whether the building qualifies as a plant and opens up new possibilities for a businesses to claim ITC on construction of certain immovable properties, particularly those integral to the service offerings. However, this new approach also introduces complexity and potential uncertainty, as it requires case by case examination based on the specific facts of each situation. Businesses, tax practitioners, and authorities will need to navigate to this new landscape very carefully. balancing the potential for increased ITC claims against the need for compliance and proper documentation. This judgment also reinforces the principle that ITC is a statutory right, subject to the legislative condition and restrictions which is given in the Act. This underscores that the need for businesses to be very careful to consider the ITC implications of their construction and leasing activities under the GST regime. As we move forward, it will be crucial to monitor how this judgment is applied in practice and how tax authorities respond, and whether there are any legislative amendments in response to the court's interpretation. The full impact of this decision will likely to unfold over time as businesses, courts, and tax authorities grapple with its implications in various contexts. In conclusion, while this judgment provides much needed clarity on several contentious issues in GST framework, it also opens up new areas for interpretation and potential litigation. It sets a precedent for interpreting similar provisions in tax laws and provides a framework for lower courts and tax authorities to apply when dealing with the ITC claims, which is related to immovable property. The judgments the judgment emphasizes on the functionality of a buildings in determining their classification as a plant, which may lead to more nuanced and potentially business-friendly application of the GST rules, while still maintaining the overall integrity of the taxing structure, which is envisioned by the legislature. As we conclude this analysis, it is very clear that this judgment will have far-reaching implication for the businesses, tax practitioners, and overall GST regime. Right. So thank you for watching this video, and I will see you in another one. Thank you.